who would believe we're already into 2024, but this morning we're going to have a presentation on what's called the Big 12, which are the most serious crimes in Vermont, and as well as a discussion of youthful offender status, which seems to confuse even those who work with youthful offender status on a daily basis. And Eric Fitzpatrick, our expert from Legislative Council, is going to explain the Big 12 and what happens. And part of why we're taking this up is we will be discussing in another bill soon additions to the Big 12 that have been recommended. Well, that passed the Senate last year and have been recommended as part of the governor's plan this year, as outlined by his legal counsel yesterday. So, Eric?
Yes, thank you, Senator Sears, and good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to talk with the committee for a little bit, as Senator Sears said, about Big 12 offenses, about essentially the big picture, what happens when a young person commits conduct that, if the person were an adult, would certainly result in the person being prosecuted criminally in the criminal division as an adult. But when it's a young person, when a minor engages in that sort of conduct, it doesn't always end up in the criminal division. It could end up in the family division with the person being treated as a juvenile. And so I'm going to talk for a moment about how it is that it ends up in one place or the other. As Senator Sears was alluding to, I discussed the same topic with the Justice Oversight Committee a little bit this past fall, and it arose there, and I think it's going to come up here again, in part because of a couple of very high-profile cases that came up over the fall and summer, where very tragic cases where homicides were allegedly committed by minors. And so that led, I think, to some questioning, as Senator Sears said, as to, well, how does a minor end up in the family division being treated as a juvenile, or sometimes in the criminal division being treated as an adult? It's not always 100% clear, but hopefully after this discussion it will be a little clearer in any event. So, as I say, the big picture topic here is, when a young person commits unlawful conduct, how do they end up either being treated as a juvenile in the family division or as an adult in the criminal division? Where that minor ends up obviously has substantial consequences for the person. It's a big influential decision as to where that court proceeding takes place. You may recall that there's all kinds of implications when a person is treated as an adult versus being treated as a juvenile. There's the confidentiality aspect. Proceedings in the juvenile division are completely confidential. The records are confidential. The hearings themselves are confidential. They're not open to the public. The disposition is confidential. The name of the minor involved remains confidential. Even in the court decision, if they're treated, they're only referred to by their initials. They're not given, the name is not printed in the court decision. Whereas if it's in the criminal division, it's entirely public, open to the media, open to anybody and member of the public. The records are public records. They can be searched. So a very big distinction in terms of confidentiality and privacy for the minor involved. As well as that, there's how the minor gets services. If you're in the juvenile, if you're treated as a juvenile in the family division, you're under the supervision of DCF. So you have a treatment plan. You have a treatment plan that's based on rehabilitation. You have services that are provided by DCF. None of those things are going to be available to somebody who's treated in the criminal division, because that person is under Department of Corrections supervision. Entirely different set of services, entirely different availability for how the minor is going to be treated. And lastly, and also very importantly, is the fact that if you're in the family division as a juvenile, the records are sealed at the end. Whereas if you're, and that means you're not going to have a criminal record. Think of we've talked in this committee quite a bit about collateral consequences of criminal conviction. That's not going to attach if you're a juvenile being treated in the family division, whether it's housing or employment or travel to foreign countries, possession of firearms. There's a lengthy list of collateral consequences that apply when someone's in the criminal division, but not the family division.
I'm just wondering, in what we passed last year, wasn't there a piece that allowed the sealed information about guns to go to the mixed database?
Yes, exactly. So there was that provision in part because there was sometimes had been seen as a gap
Yeah.
as to whether or not those records but it's a very limited exception. But yes,
So
that's right.
in other words, that escapes the sealing process just in that limited way.
Exactly.
Yeah, okay.
Yeah, exactly. Yeah. So yeah, a number of collateral attendant consequences and results that would happen that are very different, depending on whether the young person is treated as a juvenile or an adult. So those are these two options that I've described right so far: juvenile in the family division, adult in the criminal division. But you may recall also there's a third option, and that third option is known as youthful offender, sometimes YO
Where the
for short.
confusion often comes in.
Yes, and I think maybe some of the confusion arises from the fact that youthful offender is kind of a mix of both the juvenile and the adult proceedings. And in fact, I'm sure senators will remember this, back when this was initially put into place, it had been in place. I started in 2000 was my first year, and I remember at the time it was referred to as a blended sentence. That's what people call, when someone said blended sentence, they were referring to youthful offender. And the reason for that, the reason for the term, I mean, is that it's a blend. It's a mix of juvenile and adult. And the way that works is that if someone qualifies, if someone is eligible for youthful offender treatment, they are treated in the family division as a juvenile, and they get all those services that I just mentioned that would be available to a juvenile in the family division, you know, from DCF, treatment, counseling services, confidentiality, all those things apply as if it were a juvenile proceeding. And if they successfully complete their youthful offender treatment, then the record is sealed, just as it would be for a juvenile case, and there are no records of it, limited exceptions, as you were mentioning. However, if they don't successfully complete, they fail to comply with their juvenile probation, for example, they don't do what's required of them as part of their sentence, then the case is transferred to the criminal division, and they are sentenced as an adult. So that's why it's sort of a blend, you know, it's a juvenile case that's in the juvenile division. If you don't comply, well, they try and work with you to, you're not all of a sudden bumped to the criminal division, they work with you within the family division. In this case, it can potentially move over back to the criminal division, and that's where you get your sentence. And you can almost think of it as a carrot and stick approach a little bit. You know, you have this carrot of, well, if you comply with your sentence, then you're not going to have a criminal record. You're going to go through the system, and that won't be something that you have to deal with for the rest of your life. And you'll have the treatment from DCF. You'll have confidentiality. Your name won't be out there in the public. You get all the benefits. But there's also this negative consequence, this stick that's hanging over it, which is that if you don't, you could end up back in the criminal division, and then your name is going to be public, and it's going to be an adult proceeding. So that's the theory. I think it went into place in the 90s. It's been on the books since then. It's been one important point about it, actually, is that I think as part of the Raise the Age initiative, when it got started in 2018, the youthful offender status is available for older young people than your standard juvenile offender treatment. So you can be up to through age 21 and obtain youthful offender status. So you might have committed an act that would ordinarily either end up with you completely in the criminal division, but you could actually, it's a way, if you think about it, a 20-year-old who committed an act that would ordinarily be a criminal case in the criminal division, there's this youthful offender option that might be available as well. You could get to the family division that way.
Senator Baruth and Senator Hashim and Senator Bowles.
I'm just wondering about initiating the choice of one or the other. Is it the prosecutor or is it the judge? Or both?
Yeah, there are a couple of ways to initiate, and both would be the answer depending on the option. And thank you for the segue. I was going to segue right into because the next sort of issue, the question that would come up is we just sort of describe the three pathways, right? The three avenues. Well, the obvious question is, how do you get into each one? Just for a second before I answer your question, and that's actually another excellent segue. We're handing out this list, which is, because when you're talking about which pathway you end up on, there's really two moving parts to the answer to that question. What was the offense and how old was the kid? So what was the offense really means a Big 12. Right, and that's what this is, and it often helps to say, people often ask, well, what is the Big 12? There's some extras if you want to pass them around. So questions are going to be, what was the offense? And that really means, was it a Big 12 or not? And you may remember last year, in Act 23, you did some work on the Big 12. Remember, you added, for example, in each of these offenses, whether it's aggravated murder, manslaughter, etc., you added, or an attempt. Remember, the attempts were added last year. And a couple of aggravated too, I think, aggravated sexual assault of a child, aggravated sexual assault were also added. But still, it's 12, essentially. And the big picture on that is, if you're age 14 to 18, right, and you commit a Big 12 offense, you start in the criminal division, generally. If you're age 18 and younger, and it's not a Big 12 offense, you start in the family division, generally. Now, there's some motion options where you can move from one place to the other. For example, even a 12 or 13-year-old who commits a Big 12 offense starts in the family division, but it can be motioned up to the criminal division. Non-Big 12 felonies, for example, start in the family division because it's non-Big 12, but there's a motion process to move them up. But generally speaking, Big 12 defines it. If you're 14 to 18, it's a Big 12. You start in the criminal division as an adult. If you're 18 and under, it's not a Big 12. You start in the family division as a juvenile. Now, to your question, what about that third option? What about that youthful offender option, that third path? Well, at that charging point, there's two ways you can get to the family division as a youthful offender. One of them is known as the direct file. Now, direct file is when the state's attorney has in front of them a Big 12 case, right? One way this is going to work. All right, they have an aggravated assault, for example. Now, it's an aggravated assault, say a 14-year-old. Ordinarily, that starts in the criminal division, right? But there's an option to do what's known as a direct file. They can direct file that case in the family division as a youthful offender. Can't direct file as a juvenile case, because as we just talked about, if it's a juvenile proceeding, that's in the family division. And the aggravated assault case generally is in the criminal division as an adult. This other option is only if you file as a youthful offender, direct file. Now, the other way, just so you know, that a case could end up in the family division as a youthful offender, this goes to the second part of your question, is let's say they didn't direct file. Let's say they filed to start with in the criminal division. But then, either through discussion, or maybe more facts are fleshed out about the case, or maybe more of an understanding comes into view, people think that it might be better off treated as a youthful offender case in the family division. You can file a motion for that. So, and not just the defense. The defense could do it, the prosecutor can do it, and the court, on its own motion, can request that a case be treated as a youthful offender one in the family division, even though it ordinarily would be an adult case in the criminal division. And however that gets initiated, whether it's on the direct file or the motion process, what then happens is that it's not automatic. In other words, it isn't that, oh, okay, it's automatically treated as a youthful offender case. That's not the way it works. There's a consideration here, that's what it's called, in the family division. And that happens either after the direct file or after somebody files the motion. In either instance, the family division has this consideration here. And that's when the family division has to decide whether or not it's, quote, an appropriate case for youthful offender treatment. DCF has to file a risk assessment. That's one thing that has to happen at the beginning. DCF also has to file a recommendation as to whether or not it's an appropriate case for youthful offender treatment. And there's a number of other factors that the court has to take into account. Public safety is the first factor. Will public safety be protected or not? Are services available for the youth, and would the youth be amenable to those services? There's a long list of other factors. What was the nature of crime? Was there violence involved? What are the family supports? That kind of thing. Long list of factors to think about. And then ultimately, it's the court's decision. Is this case going to, and that's two ways it could go. The court could say, this does look like it's an appropriate case for family division treatment, so we're going to keep it here and treat it as a youthful offender, and retains all the confidentiality, all the juvenile aspects that I mentioned, although it could always get bumped back to the criminal division, as we said, for YL. Or the court might also say, doesn't look like it's appropriate. In that case, wants it back to the criminal division for treatment as an adult. I think an important point to think about there, it kind of goes to Senator Bruce's point about this sort of decision-making process at the very beginning. You sort of think how that could play out at that moment when, say, the state's attorney is looking at, say, in the case, for example, the cases that happened this year, a homicide case or aggravated assault case, whatever it is, in that moment when the case is there, that decision of whether to direct file or to file in the criminal division is an important inflection point. Even for confidentiality. Think about it. If the case is direct filed with the family division, it's confidential from the get-go. Everything about it is confidential from that moment forward. But if it's filed first in the criminal division, even if later on it's moved back down to the family division for youthful offender treatment because somebody makes a motion, the criminal proceeding part of the case is still public and remains public. So the name of the young person, the other people involved, the access to the media, all that is public until the moment when it gets transferred to the family division for that consideration treatment. So it's an important point, important decision-making point in the process.
I don't remember. That's an important part of it, the public nature of it. So, the Big 12 offense. So the charge is murder.
Yep.
If the charge gets dropped down and the person is treated as a youthful offender, does anybody know that the charge has been dropped down?
If that happened in the family division, then the answer, and it stayed there, the answer is probably
So
not.
the person, if I Google Jack Jones, that's a murder charge. We never know that it was, dropped down to attempted burglary or some other more minor offense.
That's true, because once it gets moved to the family division.
Yeah,
it's
so
sealed.
I Google the name and it's gonna come up, murder. It always reminds me of one of the kids when I was crossing the border back in the day before 9/11, and you could take kids across the border to go to canoe trips in Algonquin. And I got stopped by immigration, customs, and then they sent us to immigration because we had 12 kids with us. And I said to the immigration officer that, they're relatively minor crimes. Well, I think armed robbery is a pretty serious crime. I said, armed robbery? Who's charged with armed robbery? And turns out one of the kids tells the immigration officer he's there for armed robbery. He held up a kid with his pencil. The true story is he held up a kid with his pencil for his lunch money. And he called it armed robbery to look like a tough guy. And I thought, oh my God, George, how did you ever come up with that? But that is a reminder, if George, the armed robbery charge, was treated as a Big 12, it's always out there as armed robbery, and that's kind of unfair when you get down to the details.
That's a good point.
I wonder if there's something we can do in legislation to, and I don't want to take away I'm not necessarily interested in getting in loggerheads with the press over their access to public records, but it seems somewhat unfair that that's the record the kid's going to carry publicly through Google searches and whatever. Son?
Yeah, so just if I'm understanding right, it's not just the media and public access that way. It's actually the proceedings that happened in criminal court stay open to the public. They don't become part of the sealed record.
That's right.
Okay.
That's right.
Yeah, so there was reference made to the case just recently where I believe it was a 14-year-old initially charged criminally and
criminal court.
right, and the prosecutor's response when they were criticized was, well, it can always be moved to the family division, but there's the problem right there.
So if we look at some, if nothing else comes out of this discussion, and if we could look at that one piece of legislation, perhaps for the miscellaneous judiciary bill, that would allow, or not, And the other problem comes in when it gets into juvenile court. And delinquency is delinquency. It doesn't matter whether you stole a candy bar or murdered somebody, it's still a delinquent.
Is it, when the motion to transfer is submitted to the court, does the moving party have to include what the new charge is in that motion to transfer?
The statute doesn't say that specifically. I think it just speaks of a motion to, and just says, and upon the filing of the motion, it gets sent to the family division for consideration, this consideration hearing. So it doesn't specifically say what new charges might attach to it or what might be the proposal. I think it's just, the filing of the motion gets it moved, and then there's that list
The
of
motion to
criteria.
consideration.
Yeah, exactly.
Thank you. Yep.
Eric, Senator.
Yeah, so just a clarifying point. So if a person is charged with one of these and is started in the criminal court, and then the charges drop down to something not on the Big 12 list, they're not automatically moved out of criminal court, even though they're no longer being charged with a Big 12 crime.
My understanding of that would be, and I think that I always thought that was another way to get to the family division. So that, for example, let's say it started as aggravated assault, just to pick one, which is a Big 12, but you're saying perhaps it then the charge gets amended to simple assault, which is not on the list. My understanding of that is simple assault can't be in the criminal division because it's not on the Big 12. So that would then go to the family division. Now the adult proceedings would have still been public. But that I don't believe, unless, again, as I mentioned, there are ways in which a non-Big 12 case can get to the criminal division by motion from the family division. But unless there's a consequence in practice or a method in practice that I'm not aware of, I wouldn't read the language as permitting, for example, an amended charge that is no longer a Big 12 to just stay in the criminal division.
Okay.
But I'd be interested from practitioners to know if, well, that's a practical matter, that does happen sometimes. I'm not sure the answer.
I was just gonna say, I mean, one possible solution is just keeping the deliberation and contents of the consideration hearing confidential, but, allowing the result to be public on the portal, and just saying that, the courts found that aggravated assault or, homicide or, whatever the charge is, isn't appropriate. And so, this person's being charged with simple assault. And then from there on out, everything is confidential. If the issue is, what we're sharing with the public when these changes are made and what follows the kid around.
So you're looking for almost a little carve out that would allow it.
Yeah, that's one possible solution we could discuss further.
Yep.
Back when we did all this in the beginning, there was no, when it was just blended sentences, I remember being an advocate for that. 1994, I think it was. There was no social media.
Brave new world.
It was a whole different era.
I have just a couple clarifying questions that are not necessarily explaining how the law works, but on raise the age, we're not actually at 21 yet, are we? Aren't we still in the process of ramping up to there?
I think so.
Yes, in fact, I was gonna to raise the age exactly next, so thanks again for that segue, but I can hold out. Sounds like you have another question as well. But
Yeah, my other question is sort of a historical question and how we landed at 21 for the raise the age and not 25, which would be more in line with the brain science. And you might know historically how that number was chosen.
We thought 22 was pretty old.
Okay, the brain science didn't exist.
I think, generally, it was who could benefit from DCF services.
Mhm.
And DCF never felt they had services that would be appropriate for people over 21. That was the argument, as I remember. But, you know, also, quite frankly, at that time, we thought people were guns.
Right. So just evolving data has
Yeah,
left that out of sync. Understood. Thank you.
And, because there's a.
No, that was
Right. So just to transition for a moment, again, so everyone's, has the right foundation as you start talking more about this topic. But to refresh everyone's recollection on raise the age, and as I was mentioning earlier, and we looked at the Big 12, remember I said, well, if you're 18 and under and you're charged with a non-Big 12 offense, you start in family division, right? Well, until 2020, that had been 17 and under. It was, whoops, sorry about that. Apologies. Until Raise the Age started, step one of Raise the Age, which was implemented in 2020, that had always been top age of 17. That bumped up 1 year to age 18. So 18 and unders, which is the case now, commit non-Big 12 offenses, they start in the family division. That was step one of Raise the Age. Step two was intended to raise that another year so that it would be anyone 19 and under who had committed a non-Big 12 offense that would start in the family division. That has been bumped out a couple of times. I say bumped out, the implementation date has been extended a couple of times by this committee and by the legislature. So originally that was scheduled to go into effect, I think, in 2022. And then it got bumped out 1 year to 2023. And then last year in Act 23, the legislation we were referring to earlier, where you also expanded the Big 12 a little bit, that same act bumped it out another year so that as of July 1st of this year, this coming summer, 2024, that's when the 19-year-olds are scheduled to come into the family division if they commit these non-Big 12 offenses. So if no change is made to the implementation date, that would go into effect on July 1st, 2024. I think you may recall that also in Act 23 last year, it directed DCF to file a report as to sort of a progress report and how they were doing. Because remember, the reason that that's been bumped out a couple of times is this committee is starting with COVID, and then over the last couple of years, it's heard testimony that the services weren't in place yet, that the necessary levels weren't ready to accommodate that influx of people. So you asked for a status report as to how DCF was coming with accommodating the additional influx of people that raising it to 19 years of age would begin. And I think that report is on the website now.
It is, and I think that it's on our committee webpage right now. But yesterday, Jay Johnson referred to it as the administration's preference is to have it delayed indefinitely until the services are in place. And my position, and I think this committee's position, as well as the House Judiciary's position, is that we don't mind giving another year for them, although we want more, some progress made. But then to give them until everything's in place means that it's possible it would never happen.
If the description of the committee's opinion is including me, my memory is that last year that was our position. But we had yet to say that this year.
Oh, yeah, you're absolutely right.
Yeah, okay, yeah.
The good news or bad news is the House has agreed to take that issue up first.
Yes, my recollection is Senator Burris, yes, that was our position last year.
Yeah, but this year is a different year. We have not taken a position as a committee or anything. But I spoke with Representative Lalonde, and we agreed that they would do it as part of miscellaneous judiciary bill and take it up first. Then obviously we get to act on that.
Yeah, I'm curious, and maybe this isn't the right place for this question, but how many 19-year-olds are we actually even talking about?
Well, that was one of our questions. So it's a good question. Hopefully
someone will be able to answer.
Yeah.
Perfect.
I think it's one of the things I asked before we started, when I asked Eric, do you have other?
Nope, that's it for what I have.
Eric, thank you very much. It's a
Sure.
very good report, good, helpful.
Absolutely, glad to do it. Other questions, let me know, and I'll stay and listen to some of the witness testimony.
Yeah, just if, you know, from my perspective, if we can take a look at how to make sure that the public, at least part of the public record is that the charges were reduced and that the person was treated as a youthful offender so that they're not carrying around for the rest of their life a murder charge, you know, through public, right, you know, that,
Yeah,
since it's secret what happened.
yeah, that makes sense. I'll think about that. Thank you, Senator Sears.
All right, our next witness is, Tyler Allen from Department of Children and Families. We'll answer all the questions we have. Good morning, Tyler. Happy New Year.
Good morning to the committee. Thank you. Happy New Year to you, Senator, as well. To introduce myself to the committee, my name is Tyler Allen. I'm the Adolescent Services Director for the Family Services Division of the Department of Children and Families. With me today was supposed to be Lindy Boudreau, who is our Juvenile Justice Director. She would have been a useful person to have in this room because I noticed some of the conversation we've had around Big 12 offense, youthful offender status, as you know, how that compares to delinquent status, criminal status. Those conversations can very quickly get into the weeds, and that is definitely her wheelhouse. I'd like to kind of extend my apologies. She wasn't able to make it today. She certainly can come back to committee at any point if we have more questions that are unanswered and you'd like to get into a more in-depth conversation about that specifically. I came prepared today to talk a little bit more about probably similar to the testimony that we shared, Commissioner Winters and Deputy Commissioner Radke shared at the Joint Justice Oversight Committee last month. I recognize that there's folks in the room who've already heard that conversation, so I don't want to belabor it too much in the interest of all of your time, but I'm happy to go to any level into questions that come up. One of the questions I heard already this morning is a conversation about how many 19-year-olds we're talking about. We did take a swing at that question in the report in the way that we could using court filings. Of course, this is a population that isn't currently coming to DCF right now, exactly, unless they come in through a youthful offender route. But how we got at that question was to, I'll start my testimony with addressing that question while it's at top of mind. You'll notice if you find that report about halfway through, there's a couple tables, and one of the tables it's labeled court filings of 19-year-olds, and this is for the past year. And in that, it looks like we identified a total 298 filings of 19-year-old in that time. Now, those are filings, those aren't necessarily individuals. Folks could have multiple filings in that time, so we don't know exactly how many that was. The data we have doesn't break down that way. But as a general idea of how many new cases would be coming this way, 298 was the total filings, but several of them already were either in DCF or would have gone into DCF as a direct file into youthful offender status. So we kind of peeled out a couple numbers out of there that we already are in our catchment. Again, the drive of that report, the drive of that report was really describing what is the condition of DCF's capacity to serve a juvenile justice population right now. And it was all geared towards the idea of what our approach is moving towards continuing the Raise the Age initiative. So the number we landed on was 109 new filings in that case. 87 of those would be misdemeanors. 22 of them would have been felony, non-Big 12 offenses. Those would have been cases that wouldn't have come through DCF at all, and they would be quote unquote new to DCF. That would be kind of recognizing this is an expanded population we would be serving if we opened up delinquency to 19-year-olds. I did want to make sure that the committee was aware that when we talk about the raise the age expansion, it doesn't go up to 21, do go up to include 21-year-olds. Raise the age only goes up to including 18, and then this year or whenever we do the next step of raise the age, it includes 19-year-olds. I'm seeing a question, Senator.
Yeah, so that 100, again, is filings, not individuals.
Correct. 109 filings is what we came up with.
109. And then, so you said 87 misdemeanors, 22 felonies, that only adds up to 99. Where are the other 10?
How did I get to that 109? Now I'm looking, those numbers must have changed. We have 35 felony Big 12s.
Okay.
87, wouldn't that be 107? Wasn't that 109, 87 plus 22? My math might be wrong here. I thought that was 109.
I was gonna say, I only get 99 when I add together 87 and 22, but that's fine.
87. Well, I apologize if our math was wrong in there. I think we got, but whatever it is, we're looking at about 100 cases of new, and those are filings. Those aren't necessarily individuals. And I would say we'll see what the Department of Corrections would say in terms of number 19-year-olds they're serving with their population. I just identified that there probably will be a difference there, because the response that DCF would take to a misdemeanor crime may look different than who actually winds up in a correctional facility or something like that. So the response of the two different departments might look a little different, or how those numbers come out. And I think that's understandable. So we aren't talking about youths who would likely be going into secure placement. I think a very small portion of those youths would need to be placed particularly securely, because a lot of those youths would be Big 12 charges that would be originating in the adult system anyway. So in terms of what a probationary response is and things like that, that may look different from a DCF perspective. So that was one of the swings we took at the question. The other swing we took at it was to look at the numbers through how our caseload has evolved as Raise the Age kind of came into play, and indeed before Raise the Age. We think of Raise the Age along with the changes made to the youthful offender status as being part of kind of a overarching broader thing, which we think of as juvenile jurisdictional change, because obviously there's a couple different ways that juveniles can come into contact with DCF and be served through DCF, and just expanding that upper limit of what delinquency means is only one of those ways. So if we look at the kind of impact to DCF since 2016, there's a table on there, a chart, which shows kind of a trajectory of increase, expanding quite a bit in 2019. And then as the pandemic sunk in the next year, we had a dip overall in cases. There was a lot of backlog in that time, followed by a trending increase. Now, these data are imperfect because these aren't differentiating youthful offenders from delinquency cases. As folks in this committee are likely well aware, one of DCF's ongoing struggles has to do with our antiquated data systems, which collect and track these data. And so as we put new factors in, like we have youth over the age of 18 that we're trying to enter into our system doesn't have the capacity to organize and track all that. So they're lumped together, youthful offenders and general delinquents, but we approach those cases relatively similarly from a service provision perspective. So this is just kind of highlighting the overall impact of jurisdictional changes to DCF's kind of juvenile justice catchment responsibilities.
Website.
I can't either. I was just trying to, I can't get it.
I was having issues yesterday too, so I wonder if it's down for service.
Yeah, maybe.
Like yesterday it was getting frozen a lot, so I wonder if they're trying to fix it today.
Maybe. We're not able to see the report. I was trying to go to the report.
I'm still able to get it up on the screen.
Maybe
I'm still able to.
I'm
on the website.
it might be helpful if we printed out the report from DCF. So committee members I was just trying to find it on the web and I couldn't access the website. Go ahead, Tyler.
Okay. And when we find that, I'm happy to go back into that at all. I'm also happy to share screen if folks want to see the report that, that I can have up on my screen, especially looking at these tables.
I think one of the important questions is how many 19-year-olds might we expect to be new adds to the DCF, and what programs would they require? And that, I assume you're still studying that.
Yeah, that's still an area of study. I will say that's that first table I talked about, which we're talking about roughly, my estimation was 109 new filings. That probably would boil down to 70 new cases. But that's just me kind of taking a swing at it. If you factor in the fact that some of these are multiple filings on individuals. Some of those also, there might be avenues for diversion that could change those numbers differently. What the dispositional outcomes also isn't attached to that. I think an area of inquiry around Raise the Age initiative would be really looking at the data from a recidivism perspective and what the dispositional outcomes are. We're not that far into the Raise the Age initiative to think, to be able to say conclusively what happens at the end of that. But we do have a couple years of data, and I think that's why we tried to get there from the idea. This is generally what DCF is how it's expanded services. I appreciate the question about what services we need to serve this population. We have a couple programs in place. Our hope is that we can expand one of those programs up to a 10-bed facility. Again, I think most of the Raise the Age individuals aren't youth who would require placement outside of their home environments. I think a small fraction of them would be, although there are some that would require that. And so we do have one contract that we are seeking to have expanded by the end of this state fiscal year to be a 10-bed, I believe a 10-bed program that we have access to.
That wouldn't be in Bennington, would it?
It would not be in Bennington. There is a program in Bennington that serves an over 18 population through CEOL. And that is more of there's 2 apartments that are used and that we can use. And we have some programming built around there for youth who are kind of transitioning into adulthood. And so depending on the situations around those youth, depending on what they've gone through in terms of kind of their residential history, that program's really built around integrating them into the job market and transitioning into adulthood. So we do have some capacity in Bennington as well.
Well, I'm familiar with the Bennington departments there.
Yeah.
Interesting. Yeah. Yes, the question is, what are the prospects, going back to juveniles, for a secure facility, and are there any updates that you can give the committee on when we might see the Middlesex program open?
So thanks for that question. We are continuing to move forward.
I'm sure you're happy to have that question.
We are. I mean, this is a good time. We have some positive news to report out. Middlesex is well underway. The construction is due to complete at the end of this month. At my last check, we're still on track for that. I think the facility will be ready for use before we're able to get programming in place to use it. But my hope is that will be within, as little as a month or so afterwards. While we're trying to line that up, we have an assurance from a provider who we have a longstanding relationship with, who is interested in taking on that work and being a partner in development of secure facilities kind of moving forward. That's kind of in contract point now, where it's a discussion. There's an assurance that there is an interest there. The committee might be aware that even as little as a month ago, even as little as a month ago, we were simply operating from the perspective that we had an RFP that went unanswered, and that when we reached out for for feedback on what was it about the RFP that required, that we needed to address and change. We couldn't get any negative feedback around the RFP. It was simply, I think, the state of the state when it comes to provider networks looking to build right now. And so since then, we had somebody who we've been able to talk to, who has expressed interest in it, who we feel strongly has the capacity to. So I think we've got some open road ahead of us to develop that program. So my hope is in a couple months' time, we'll be able to have a temporary secure facility operation. The other change to that, or the other update on that conversation is I'm sure much of the committee is aware that the Supreme Court has issued a finding in Newberry that that we're very satisfied with, that we can proceed with development of the programming there. Obviously, in the couple of years that it's been going through, litigation and the kind of the legal system up through the Supreme Court, we didn't want to stop all things. So we have a number of avenues moving forward, one of which is being Middlesex. That's part of the contextual difference from where we were at when we were last talking about Newberry. So I think given the fact that we have an opportunity to use this and we have very much have an interest in working with that program, working with that community building program there. Obviously, as the report identifies, there's a great need to expand our high-end system of care, as we refer to it. And one of the tiers of that high-end system of care is hardware secure treatment programming. There's obviously an interest in that conversation, but also that's what's happening temporarily in Middlesex, and that's what we have other plans for also around the development of a secure campus. And so I think we would very much want to have continued conversation with that provider. Part of it is where the interest of the provider is and what they're able to do and willing to do. We haven't had the opportunity to all sit down in a room together and strategize around how we want to move forward from here. And the other part is what we can do to re-engage the efforts of that community. Obviously, a couple years of going through legal battles has had an effect on our relationship with the community. It has always been of primary importance, or it has always been of great importance to us to be good neighbors and be good partners with wherever DCF is serving the youth, serving Vermont youth. And so we need to figure out how to re-engage that community in a way that whatever programming we're able to have there works also with them and for them. And to that end, there is a facility planning stakeholder working group that is also brought up, and community members from Newberry have appeared in that public meeting and have shared that it's important that we're engaging communities in those conversations. And so I think we have a broader and different approach now to working and gathering community feedback. And I think that's part of what our strategy moving forward in Newberry has to be.
Senator Baruch has a question.
Thank you, Tyler. That was a question I asked Jay Johnson yesterday. She referred me to you, so it's super convenient that you were scheduled for this morning. Am I understanding you correctly that you're saying it'll be something like an all of the above strategy? So the Middlesex temporary facility, maybe the work that's been done in Brattleboro on a couple of beds, and Newberry, we would be working with all of those as possibilities?
I would say that we don't want to discount the opportunity of working with Newberry. That building is beautiful. There is interest in that area. That provider is strong. We would certainly like to be addressing our high-end system of care needs with whatever resources are available. I can't concretely say where the program, the owner of that building, lands at this point until we have those conversations. But when I think about Wyndham, that's referring to one of the different, remember, there were 4 tiers to our proposed system of care. That was psychiatric residential treatment. That was hardware secure treatment. That was hardware secure crisis stabilization programming, and that was staff secure crisis stabilization programming. So Wyndham is something we are proceeding with. That is a staff secure crisis stabilization program, similar to what the programming in Bennington that we've already talked about. CEALD offers their programs we refer to as crisis stabilization, which means they're able to address youth with a kind of a broad range of needs, closer to an emergency basis. Rather than having a highly structured, this is the very specific treatment modality, and this is the kind of population we're looking to bring in for a very specific purpose. I think of that in terms of treatment, so the PRTF level of treatment, or the long-term secure treatment program.
Senator of the House.
Sorry.
I'm sorry, Senator Baruch has a follow-up.
Just a quick follow-up. So I'm trying to parse your words a little bit. So are you saying that Newberry remains up in the air? Or are you saying that if that provider doesn't want to do it anymore, you'll be pulling back? And I'm not trying to rush your decision-making process. It's just that post-decision in the court, people are wondering what is the status.
I'm just hesitant to commit concretely what we would like that program to look like without having discussion with the people that would be operating the program, and that we recognize that the landscape has changed a little bit since we were last viably talking about Newberry. Because we do have Middlesex in play now. So I don't want to say concretely that we're walking away from Newberry, because we very much want to make that program work, but we want to make it work in a way that is going to work for the community and work for the program provider.
Thank you.
Your 4-tier system of care seems to all be residential out of the home, and I'm wondering what tiers there are really grounded in community and family. As we know, youth who have functioning families and community supports are far more likely to be successful. And so I'm wondering if there are additional tiers meant to keep kids out of these residential facilities. And my other question is sort of an ask around the supports and services in the Newberry community. I know a lot of time I work with this population in my outpatient practice, and a lot of time I hear from families like, I can't go visit my child because they're 3 hours away or out of state, or there's no job potential for my child in the community they're placed in. And so I'm just really trying to think about, from a holistic standpoint, where your plan is to really set these youth up for success.
Thank you so much, Sharon. That's an incredible question. And I will say this system of care response that I've been talking about, it is heavy on the residential, because it's really about addressing the question that was at hand, has been the primary driver behind a lot of the struggles that DCF has had in the past couple of years, or I should say Family Services Division has had, which is that there was tremendous loss of capacity within our residential system of care, both access to in-state and out-of-state. And what that has done is created log jams within our residential system of care, which have youth extended too long, or sometimes in the programs that aren't best meeting their needs, for lack of alternative places to go, for lack of others. So I absolutely agree that a vital and necessary part of response needs to be on the other end of the equation, expanding of services to foster care. We do have efforts in place to expand to transitional services in the home, what are more akin to wraparound services from a mental health standpoint. We have our own, which is called support and stabilization. We've expanded that contract. So we are doing a lot on the other end for the transition. But the problem remains that we've lost so much residential capacity, particularly at the highest end, between the closure of Woodside and then the huge reduction in residential workforce access, that's been an area of focus. And this report was really designed to address that high-end system of care. So it's not speaking to all the efforts of Family Services. It's just the parts that I've been in. That's why I'm speaking to it in that front.
Other questions for Tyler? Tyler, thanks so much for joining us this morning, and I realize you were the appointed one. And,
it's been a
so
pleasure, Senator.
Thank you very much. Our next witnesses are from the Department of Corrections, Josh Buckenwood, Gary Marlin. You want to come up together, or you want to?
We get along pretty well.
Yeah, the department often gets left out of the discussion of youthful offenders, and yet is a key component.
We would be happy to be left out of the discussion, sir.
And also the Big 12.
We're trying.
I understand that, and, I think part of what we would start with is the level of success that there is. At this point in time, this morning, the Department of Corrections has 0 juveniles under 18 in correctional custody. We have 0 18-year-olds who are incarcerated. We have only 1 18-year-old who is under field supervision. Not speaking of YO, that's a separate, that's why I brought Gary, because even I don't understand YO. But straight under probation, there's a single 18-year-old. When we move up to 19, we talk about a slightly bigger category. We have a total of 13 19-year-olds. 7 of these are incarcerated, 600 field supervision. Those are all listed violent offenses. The majority of those are Big 12 offenses. A couple of them are not Big 12 offenses, but are listed violent offenses. So that's where we sit in terms of our numbers at this point in time. I know there's been discussion about both expanding or contracting the Big 12, and the department really doesn't have a position on that, other than that we are prepared to meet. I think that's a policy decision for you guys, and we're prepared to meet that need. We're currently serving that population, that very small population I'm talking about. And if we are asked to continue to serve that population, we're prepared to do that. We've been supportive of the move. A lot of youth have been diverted from our system. I think for a lot of youth that's been helpful and successful. But we're prepared to serve the youth that are sent to us, and I look forward to Tyler and DCF having some other options available. Certainly, we've had some youth where that would be helpful to have some other options, I think.
Senator.
Do services for youth in the Department of Corrections look any different than services for older folks?
Not substantially. We're really an adult geared system, and that's how we've always been designed. We have a high school, but that's designed around an adult learner model. And certainly those services are offered, but we don't have a lot of juvenile specific services. We really are an adult correctional system. And as I think evolving attitudes and this body has sort of shifted some of that idea of where that line for adult is, but we still remain a system devoted to serving adult criminal defendants, wherever y'all decide that line is.
So if you were looking at, with DCF, most of those 7 who are currently incarcerated would be Big 12 offenses, I'm assuming, and would likely not be in the juvenile. Come under the 19-year-old, they would have been charged as adults.
5 of those currently incarcerated are incarcerated for Big 12 offenses. So would still start in criminal court. I know I've testified in front of a couple of courts around the juveniles, and one of the questions that comes up is, what are the other options? And as you are all well aware, in this state, there aren't at the moment a lot of other options. So I think for the court, sometimes they have been looking for or would be open to considering another option if they had one.
Right, I'm getting at it. If the 19-year-olds were to come under raise the age, those 5 who were charged and convicted, I assume convicted of Big 12 offenses.
Pending mostly.
Pending mostly.
Yeah.
Those 5 might remain in the adult system.
They might well, absolutely. They certainly legally, there would be no barrier
That
to
would
them
leave
retaining.
us with 2 and plus, would you say 8 on
Six on various types of field supervision.
Yeah, go ahead.
This may be a question for DOC. It might also be a question for the state's attorneys. I don't know, but what I noticed is you said the majority of them are pending. When someone's being treated as a youthful offender, is there how they're treated while their case is still pending different than how an adult is treated?
So none of the folks I'm talking about would be treated as, are being treated as youthful offenders. These are all cases that are completely remaining in criminal court at this time.
Right, I understand, but if, I do understand that, but I guess my question is sort of about that youthful offender status or the juvenile status, and if they are treated differently in the pending phase than someone who's being charged in criminal adult court. So forget the numbers.
Okay, I'm trying to follow your question because I think we're talking about two different groups. And so the group that is currently, those 7 more incarcerated, those 6 are under field supervision, none of those are being treated as youthful offenders. Those are all adult criminal defendants.
Yes.
There is a separate group that Gary talked, who have moved to the youthful offender already. And you're talking about the group that's still criminal?
So if the group that is currently being treated as in adult court were to be treated as youthful offenders, would how they are treated while their case is pending be different?
Absolutely.
Okay, thank you.
For starters, they wouldn't be incarcerated with
Yes.
us.
That is what I was trying to get at.
Okay.
Sorry for being fuzzy.
Kind of helped me. I remember 100 years ago when we did blended sentences and I could call the probation officer and they'd come down to 204 and read the King of Riot Act, and then the social worker would come in and say, now be a good boy. What is your role today with the youthful offender who's
I'm gonna defer to Gary on that, because
Okay.
really that is his bailiwick.
Sure. I'm Gary Marvel, Field Operations Manager, Department of Corrections. Just to kind of illuminate a little bit the question you're asking, you're kind of talking about statuses, and I think what Josh is referring to are people that are detained, where you can only be a youthful offender in the community. You can't be a youthful offender if you're incarcerated.
Okay, thank you.
So you want to know about our role center?
Yeah, what role does the local probation and parole department
Sure.
play with the DCF, and how do you work together?
Sure. So yeah, I think Tyler touched on it a little bit, but what would happen is you get the consideration report, which we participate in the consideration report as much as necessary. So there's 2 different screening instruments that we do as shared departments. The YAZI would be the one that DCF does if the youthful offender, potential youthful offender, is over 18. Then we would do our assessment tool, which is the ORAS, which it gauges criminogenic risk. If they're specific to a sex offense, we would do our instruments there, which is the SAC-9 and the BASER. So we would participate by doing those instruments and providing the information to DCF to be included in the consideration report. And then that would go, and you would have merits to determine whether or not we're going to go in that direction, and then the final disposition report. We're involved as soon as we're asked to participate in the consideration report.
So after the determination has been made that this youth will be treated as a youth offender, what is the role of the department in terms of supervision, in terms of if behavior gets out of control, but not so much so that you want to completely end the youthful offender arrangement?
So when the case plan is submitted to the court, during this process, we identify who the lead agency is going to be, and that typically is going to be DOC if they're over 18. Although we can get involved with somebody under 18, and for example, recommendations around electronic monitoring, but typically it's 18-year-olds and up. We end up being the lead agency. And what that basically means is they get assigned a probation officer who's going to be the primary contact for that person who's on supervision now. And then we would supervise them as a youthful offender. And it's not much different than in terms of how we would supervise someone who is on probation, depending on what the needs are identified in the case plan. So, and we have probation officers that are specifically trained and that have been, that have reduced caseloads for dealing with that transitional age youth in many of the districts.
Is DCF's role in this?
They stay involved. We still collaborate with them regularly, and they are still the ones that will be the ones doing the filing, because it's family court. It's still oriented at family court. So any information we need, like if we need to initiate a violation, for example, that information would go to DCF, and then they would have to file the report.
When somebody's successful it's like a deferred sentence, am I correct?
Correct.
And then you file with the court that they've succeeded or they've completed their ornaments, and then the case is expunged, or what happens?
So what happens, every 6 months, we review the cases, and 3 months, and if it's a case where we're involved as the lead prior to 18, it's 3 months prior to 18. That's a collaborative discussion between DCF and DOC, and we determine if we're going to review, if we're going to file with the court to ask that they are discharged from probation.
You may not have the figures today, but it would be helpful to have them at some point. Over the last few years, how many cases have we had of youthful offenders, and how many have successfully completed?
I have the current ones. I would have to look at, I have the current ones we have on youthful offender status now, but I would have to, that would be a bit of a data dive.
I'd be really interested to know how, if that system is working. You know, given the nature of many of those crimes, that kid, you know, it has to be a big part of it.
It could actually, if they're above 19, I think 19, 20, 21, then you could get a youthful offender for misdemeanor.
Any statistics that you could provide us would be helpful in understanding either the success or failure of places we should look for further legislation to help. You know, as a strong believer in the youthful offender system, and a system that I believe, you know, helps a lot of young people. And it's one way of getting at the 22 and the 21 and under age group. You know, even if we don't do raise the age next July 1st, we at least have youthful offender available. So, yeah.
My colleague behind me did suggest that I speak to you guys briefly around some of the sight and sound separation issues we have for those youth who are held incarcerated, because those certainly do impact the conditions of confinement for a younger person who's held incarcerated. And just for this committee's
Even under 19?
Yes.
And even 19-year-olds?
Not 19-year-olds, 18. So there's two different categories. There's under 18 and then there's 18. So for individuals who are under 18, federal PREA regulations require that we maintain sight and sound separation for them in their living unit. They cannot have contact with adult offenders when they're in their living unit. They can have supervised contact outside of their unit if the department deems that appropriate. The challenge is that we routinely have few or none of those individuals, which is both a success and a challenge point. But if we have a single 17-year-old, for instance, we have to keep them separate in their living unit from all adult offenders, and they may be the only person in that category in our building. In fact, most of the time we have one, 0, 1, or 2, and most often it's 0, which is fantastic. But when we do have one, we have to maintain that sight and sound separation in their unit. If they are 18 and under, there's a different set of regulations under the Juvenile Justice Reform Act that requires that we maintain sight and sound separation unless a judge deems it in the interest of justice that youth have contact. Now, thus far, the 18-year-olds who have come into our system have routinely asked, after hearing sort of what that looks like in practice, that they be allowed that sight and sound contact. Because when, again, as we might have 0 or 1 or 2, it could be a very, very lonely status if you're the only person, or you only have one other person. So generally, and recognizing that an 18-year-old in general population is a vulnerable person that we need to plan for carefully, they've generally found it preferable to be in population where they have access to more services and more socialization. But that does go through a court hearing. Certainly the youth has the ability to express their point of view, and ultimately the court has to make the finding as to whether or not it's in the interest of justice. The court cannot waive our obligation under PREA though. So for that 17-year-old or under, they will always be in a living unit separate from adult offenders, adult incarcerated individuals, and then we can do some stuff outside the unit if it's directly supervised.
Well, I guess one example was the girl from Bennington who was, I think, in Rutland for a couple of weeks.
We moved her to Chittenden very quickly.
Oh,
Yeah, we moved her up to Chittenden, but yes, the entire time she was incarcerated, she needed to be in a unit by herself. She was the only, female that we had at that point in time who was under the age of 18, and therefore in her living unit.
that's a question I forgot to ask Tyler also, on females at Middlesex, I'm not sure but anyway.
Quick question, the juveniles who are able to interact with adult offenders under supervision, what are some of the things that they might end up doing? Like what are some of the services or just activities that they can do potentially?
So, one of the things that we do pretty early on, is some communal dining, because it's a pretty structured environment, and it's very closely supervised. And so, you're gonna go to chow with a designated unit. Usually we have a unit that's a little calmer, and you're gonna live in this unit apart from everybody, but when it's time for meals, you're gonna go with a specific unit. That's a way for somebody to start getting used to this, a little bit more of that hustle and bustle population in a pretty controlled and short environment, 20 minutes at a time. Outside recreation comes up very quickly. And our educational services through risk intervention services. Those are the biggest ones, depending on the interest of the youth. And normally, fortunately, we have not had a lot of juveniles stay with us for any length of time. But we could certainly offer access to volunteer services, any other services that we have in the building. But usually, we usually look at meals as a nice initial way to start to introduce them, and then offer outdoor recreation and educational services outside of the living unit. If that person's staying in their living unit, we're still going to offer those services in the living unit. But when we want to get out, I'd much rather they attend education in the schoolhouse versus those services being brought to them.
Is there any limitation in terms of out-of-state placement? In other words, could an 18-year-old end up in Mississippi?
I don't believe there was a limitation under law that I'm aware of. I don't foresee that being something that we do. And certainly we don't have anybody nearly that young out of state. Now, I'm not aware of a limitation under law that would preclude us from doing it. But as the person for the last 2.5 years has managed those lists, it never occurred to me to put an 18-year-old in Mississippi.
Yeah, specifically Mississippi, there may be programs that are out of state.
Yeah, when we've done that,
DCF.
usually that's through DCF. That would usually be through DCF. DOC hasn't done that. We did briefly have a contract with the Sununu Center in New Hampshire through DCF for some of those juvenile placements. That was the under 18-year-olds. But that's ended. We no longer have access to that service.
Senator Bowski.
I'm not sure I'm ready, like, I'm still trying to format it in my head, but, so go ahead.
We could transfer youth under the interstate compact or the juvenile justice compact. There's a juvenile compact and an adult compact if there's.
Yeah, I had more in mind in my question, Mississippi, actually.
Mm-hmm. And is the reason that you wouldn't send an 18-year-old to Mississippi because of the lack of programming, or what's the reasoning behind why it wouldn't occur to you to send a youth to Mississippi?
When we're looking at sending folks, we look at a number of sort of stability factors, settings being one of them, but then stability factors, need areas, educational needs being one of them. Most of the youth we have that young have educational needs. It also, the majority of the population in Mississippi are individuals serving longer sentences for very violent crimes. And we always look carefully when we're talking about more vulnerable populations and putting them with that group. And I think with somebody that young, we would feel more comfortable having them in-house, so we can offer those educational services, but also just keep eye on somebody who we know is the potential to be vulnerable in our system.
Okay, thank you.
Are there any other questions for Tyler? I mean, Josh and Karen. Thank you so much for being here today. We appreciate it. We're going to take a 10-minute break and come back around 20 of